跟住燒到100蚊就3，因為你睇住我，你餵蚊啦，冇所謂啫。我食紅燒啦，嗱餵蚊一齊喺度。
梁美芬，
我咪要攞個即係所謂政府嘅監督嚟就我因為我行街，我一日執幾轉咁燒老細。佢裏邊係啊，我真係唔知啲包咪拉晒，你知佢仲要啲包埋一齊嘅，係啦，真係。點啊？我砌翻都〜咁我就包嚟做打舊嘅先咯。係啊，即係你如果我中盤有30個人，一人要翻嚟，一人包嚟。
你哋攞晒佢哋就入嚟㗎啦，就馬上開始。
我要煲 OK sure
中文得嚟 ，thank you。
呢個係啦，如果開門嘅話。各位傳媒朋友，大家好，我係趙麗如，香港大律師公會嘅行政及發展總監。歡迎大家咧今日親臨採訪今日嘅會見傳媒呢一個時間嘅。公會嘅週年大會咧，琴晚就結束咗啦。5位執委會嘅幹事咧，全部順利連任。佢哋包括咗企喺中間嘅資深大律師杜鑑坤連任主席，喺佢右手邊係資深大律師毛樂禮，同埋喺佢嘅左手邊係資深大律師陳正龍，繼續咧係會做副主席嘅。 另外咧喺我最近我呢邊嘅咧就係名譽秘書及財政，繼續係嚴永增大律師喺你哋嘅最左手邊。然後最右手邊嗰位咧喺我最右手邊嗰位就係黃永海大律師，亦都會留任副名譽秘書嘅。咁而家咧我哋俾你拍多一陣照，跟住我哋就會馬上開始㗎啦。可以啦，嗬。好，咁拍照時間差唔多啦。主席咧會先以廣東話同埋英文咧作開場白發言嘅，之後就會答一啲簡單嘅問題啦。I will now briefly recap the introduction in English. I'm Bonnie Chiu, the Director of Hong Kong Bar Association, Director of Administration and Development. Thank you for coming to cover today's media briefing. The AGM of the Hong Kong Bar Association was held smoothly yesterday evening, and all the 5 office bearers of the past Bar Council were re-elected. They include Mr. Victor Dawes SC, who is standing in the middle, who was re-elected as the chairman. On his right-hand side is Mr. Morley Jose Antonio SC, and on Victor's left-hand side is Mr. Derek Chen Long SC. They are both the 2 vice chairmen. And the closest gentleman to me is the honorary secretary and treasurer, is still Mr. Eugene Yim Wing Shang. And the far right from me is Mr. Martin Wong Wing Hoi, continues to serve as the deputy honorary secretary. Chairman now deliver his opening remarks in both Cantonese and English before taking questions. Chairman, please.
各位傳媒朋友，大家好。我同我嘅團隊好榮幸能夠第2度連任大律師公會主席、副主席同埋執委。我哋好感謝會員同埋執委會對我哋嘅信任同埋支持，可以繼續服務公會同埋廣大市民。法治係香港成功嘅基石。香港推行普通法，更係對一國兩制裏邊重要嘅一環。過去2年，香港司法界面對好多對外同埋對內嘅前所未有嘅重重挑戰。我同我嘅團隊一直竭盡所能，喺此時此刻繼續以專業嘅法律知識同埋角度，喺適當嘅時候喺法治議題努力發聲。由於手頭上高有不少嘅工作係有延續性，所以我哋決定留任完成有關嘅工作。2024年對香港嚟講喺唔同嘅方面亦都係非常之重要嘅一年。政府已經宣布喺呢個立法年度裏邊必須完成基本法23條嘅立法。公會嘅立場一如既往，香港作為一個國際金融中心，就23條立法嘅目標應該係要喺維護國家安全同埋人權保障中取得平衡。罪行嘅內容要清晰，響立法嘅過程中，亦都希望政府仔細去聽各位市民嘅意見，將立法嘅影響就對於一啲守法嘅市民減到最低。公會承諾喺草案條例公佈之後，會仔細咁研究，並獨立地同埋專業地表達我哋有關嘅意見。喺另一方面，大律師公會作為一個專業團體，我哋亦都會不時提醒會員要按法律執業者條例同埋大律師嘅行為守則行事，展現行業嘅專業水平。公會早前收到有關38名大律師被投訴，就一啲由612人道支援基金資助喺2019年社會事件嘅個案裏邊提供法律服務嘅時候，涉嫌專業行為失當。公會執委會喺審視同埋分析相關證據後，已經確認咗調查報告。公會嘅紀律調查向來都係保密同埋公正嘅，但由於今次嘅投訴涉及大律師嘅人數眾多，關乎大律師嘅專業操守，同埋多宗係關於2019年社會事件有關嘅個案，公會認為係涉及公眾利益，所以決定喺唔公開投訴人同埋被投訴人嘅身份嘅情況下，公佈調查結果。投訴人係喺2022年5月向公會投訴，公會馬上責成咗一個特別嘅調查委員會展開調查。委員會主動聯絡咗有關嘅持份者，搜集咗相關同埋補充嘅證據。經過1年半嘅獨立調查，委員會將調查嘅結果交咗俾執委會通過。 投訴人指大律師涉嫌專業失當嘅行為，其實可以分為3類嘅。部分大律師係涉及咗多於一項嘅投訴。第一類嘅投訴涉及咗7名嘅大律師，指佢哋喺有關法庭個案裏邊以義助服務形式延聘，即係我哋英文所指嘅 pro bono。但係實際上高咧，指控話佢哋係有收取費用，所以係誤導咗法庭嘅。經調查之後咧，我哋確定咗佢哋7人有一部分的確以義助服務形式延聘，或者其實係從來未向法庭去表明過自己係用呢個方式去被延聘嘅。所以嘅結論係冇足夠嘅證據顯示呢類型嘅投訴係成立。嗱，第二類投訴涉及咗26名嘅大律師，指佢哋喺有關訴訟嘅收取有關訴訟嘅批准嘅費用嘅時候咧，冇經過指示嘅事務律師直接向真普選聯盟有限公司或者基金收取咗支票。調查委員會收集咗有關嘅證據之後，喺26名被投訴嘅大律師裏邊，有24名都可以攞出有關嘅文件，證明咗佢哋嘅有關嘅支票其實係由佢哋受指示嘅律師樓交俾佢哋嘅。另外有2名涉事嘅大律師咧，就冇保存咗有關嘅文件記錄，但係提交咗部分或者大部分嘅文件記錄。技術上高，佢哋係違反咗有關嘅守則，但係冇證據證明佢哋係繞過指示佢哋嘅律師事務所或者律師行。喺呢一個情況之下，我哋嘅結論都係有關嘅投訴未能成立。第3類投訴涉及29名大律師，指佢哋同意收費視乎一啲叫做或有事件，英文我哋叫做 contingency fee， 或者俗稱按條件收費嘅安排，咁就係違反咗有關嘅守則。委員會喺搜集到有關嘅邀聘文件上高睇到嘅相關字眼裏邊，其實冇批准或者類似嘅字眼。根據基金會向外公佈嘅資料咧，大律師喺有關案件嘅服務收費，其實所獲得嘅律師費，其實已經係公佈咗劃一嘅收費金額嘅。不少涉案嘅個案咧，獲有關嘅文件，亦都係關於一啲提訊嘅聆訊，我哋叫做 mention hearing。所以其實喺嗰啲嘅聆訊裏邊，亦都唔涉及一啲成功或者不成功嘅例子。喺呢一啲嘅投訴裏邊有2個個案，涉事嘅大律師同樣冇保存全部嘅文件記錄，所以技術上高係有違規。但係我哋亦都冇足夠嘅證據證明佢哋係按條件收費，接受咗呢一類嘅安排。所以我哋嘅結論都係第3類嘅投訴都係唔成立嘅。嗱，總括而言咧，第一，我哋冇足夠嘅證據顯示嗰38名大律師係如投訴人所指有專業行為失當。第二，我哋嘅調查亦都冇發現所涉及嘅個案有一啲誠信嘅問題，或者有刑事嘅成分。第三，公會一致通過係無需向大律師記錄審裁處呈交呢啲被裁定不成立嘅投訴，所以有關嘅調查係已經係終結嘅啦。至於4名尚未保存咗全部記錄嘅大律師咧，其實佢哋係有違反咗行為守則裏邊嘅規定。公會已經向佢哋發信指出呢啲行為係違規，敦促佢哋以後要保存有關嘅記錄。根據今次調查嘅結果，呢38名大律師冇喺犯上被所指嘅專業行為失當。呢4名違反嘅個案，雖然技術上違反，都係違反咗守則。對於法律專業嚟講，其實應該係必須嚴格遵守呢一啲嘅守則。公會喺行使既定獨立管理權嘅時候，亦都一如既往嚴格咁樣去執行有關嘅規定。呢次嘅投訴同埋調查，我希望係會提醒咗我哋嘅會員必須嚴格遵守同埋執行，我哋亦都嚴格執行 有關嘅規定，可以維護工會最高標準嘅誠信要求，避免外界質疑。執委會亦都會保持警覺，並定期提醒我哋嘅會員要以嚴格嘅態度去遵守有關嘅行為守則。38名大律師同埋喺2019年相關案件嘅提供嘅法律服務。當我哋喺回望呢啲個案嘅時候，其實個數量係好多，加上佢哋處理呢啲案件嘅時候時間緊迫，其實喺香港嘅歷史同埋法律界嘅歷史上高，我哋都可以話係史無前例嘅。加上大律師行業獨立運作同埋收費嘅模式，其實外界亦都未必可能完全理解，所以佢哋對呢一啲嘅大律師嘅行為提出疑問，其實亦都唔難理解。我感謝喺整個過程中監察大律師維護專業操守嘅有關嘅持份者，同埋竭力向委員會提供資料同埋證據嘅單位同埋個人。我哋感激委員會盡力嘅調查，我哋工會亦都會喺日後把握每一個唔同嘅機會，向公眾咁解説我哋嘅規則同埋運作。龍年將至，我祝大家生活愉快，萬事如意。I will recap very briefly in English. Me and my team are, of course, delighted to be able to serve as chairman, vice chairman, and members of the council again for the first consecutive year. I thank the Bar Council and also our members for trusting us and giving us the opportunity to serve the bar and to serve Hong Kong. The rule of law is, of course, of vital importance to Hong Kong. We are the only common law jurisdiction in the country, and this is of particular importance to one country, two systems. Over the past 2 years, there have, of course, been a lot of challenges to the legal profession. But over the past 2 years, we have also tried our very best to use our professional judgment and expertise to try to explain various situations to the public and try to speak up on rule of law issues. There are a lot of outstanding work, and this is the prime reason as to why we decide to serve in this capacity again for another year. 2024 will of course be an important year for Hong Kong. The government has indicated that they will complete the legislation in respect of Article 23 of the Basic Law. Hong Kong is an important international financial center. We hope at the end of the day, a balance could be struck between national securities and the fundamental rights as guaranteed by the Basic Law. We hope the law will be clear, and in the process, the government will listen carefully to the views of the public. It goes without saying that the Bar Association will do our very best in giving our opinion when the draft of the legislation is available. On a separate note, we have released the investigative findings regarding complaints against 38 barristers having allegedly committed acts amounting to professional misconduct. The allegation against those 38 barristers related to when they were acting for various defendants charged with offences relating to the 2019 social events where they were funded by the 612 Humanitarian Relief Fund. The Bar Council has carefully reviewed and analyzed all of the evidence collected and has unanimously resolved that there was no evidence that the 38 barristers being complained of had committed acts that amounted to professional misconduct. No acts of dishonesty or criminal elements were found. Our conclusion is therefore that the complaints are unsubstantiated and the investigation has come to an end. During the investigation, we have also discovered that 4 barristers were found to have been in breach of the Code of Conduct by not keeping certain necessary documentations as required in the administration of their practice. I have therefore issued a letter of advice to the 4 members, warning them that they were in breach of the code and urging them to maintain full records in the future. Now, in relation to the three categories of complaints and findings, the first one involves 7 members, and it is alleged that they have represented that they have acted pro bono, but they were in fact paid, and they have therefore misled the court. At the end of the day, having considered all the evidence, we concluded that the allegations are not substantiated. All 7 barristers were able to prove that either they have not made the representations that they acted on a pro bono basis, or that they have never received payments from their clients. The second complaint is in relation to 26 members. It is alleged that they have received checks directly from the Fund or Alliance for True Democracy Limited rather than from the instructing solicitors. We also found the complaint to be unsubstantiated. 24 out of the 26 barristers being complained of in this category were actually able to produce documentary evidence proving all the checks in issue were sent by the instructing solicitors. 2 barristers were in technical breach of the code due to incomplete documentation being retained. Now, the third category is in relation to 29 members. It is said that they have agreed that payment of their fees would depend on a contingency, which is regarded as conditional fees. We concluded that the allegations have not been substantiated. From all of the copies of the briefs that were provided from the barristers, there were no use of the words such as subject to approval by the 612 Humanitarian Fund or words to similar effect. According to the Fund's information published to the public, the fees provided by the Fund were based on a fixed scale. There was no contingency of any sort involved. Many of the relevant briefs were also for mentioned hearing, of which there would not be any outcome in terms of success or failure. Since mentioned hearings are for procedural purposes and not for substantive determination, that conclusion, we believe, is an irresistible one. In this category, 2 barristers were also found to be in technical breach of the code due to incomplete documentation being retained. I would like to conclude by saying that regarding barristers who provide legal services in case relating to the 2019 social incidents, if we look back, we can see that those cases were unprecedented in terms of their nature, the volume, and the way barristers were instructed. It was also unprecedented due to the urgency in which barristers were instructed to act and to render advice, and the record or management required, both from the point of view of the entire Hong Kong and also the legal sector. Members of the public, of course, may not fully understand the professional rules regarding fees and keeping of proper documents and record, and it is not difficult to understand why questions are raised about barristers' conduct. We thank the stakeholders who monitored barristers on whether they have maintained their professional standards, all the individuals and parties involved that supplied information and evidence to the committee in the process of investigation. I also want to thank the hard work of the committee in question. The Bar will strive to make use of different opportunities to explain to our members and to the public about rules and operations of the barrister's profession. The Year of the Dragon will be arriving soon, and I wish you the best of luck and good health in the coming year.
Thank you, Chairman。唔該晒主席。而家係答問時間，請記者朋友提問嘅時候咧，盡量即簡。答問前先講出自己嘅名同埋傳媒機構嘅代表。Alvin 明報。
Alvin 你好。
非常，我有3個簡單嘅問題。第一咧係你頭先揾個即係調查投訴咧已經係調查已經係終結嘅。你嘅意思係咪即係指佢已經完全 close file？就算有更多嘅證，你嘅意思你頭先講咧揾個調查咧已經係終結嘅。咁如果其實係咪即係如果有更多嘅證據或者有新嘅投訴咧，你哋都唔會重新調查咧？第二咧就係你會唔會認為今次嘅投訴嘅指控咧，可能係一啲比較瑣碎咧？第三咧就係如果有人係因為擔任法律代表呢個角色，而日後喺相關嘅案件可能俾人控告咧，即係呢個行為控告一個大律師，因為參與呢個案件辯護咧，會唔會違反基本法同 ICCPR 咧？
第一個問題就係喺有關嘅調查已經係終結咗，我哋亦都通知咗投訴人同埋有關嘅會員。 當然一如以往，如果有一啲新嘅證據，我哋可唔可以排除我哋會再進一步去調查呢？當然唔可以啦，呢個階段。但係就現有嘅證據嚟講，有關嘅調查當然係完成咗。我答咗你第3條問題先。你第3條問題就係話，如果有一啲嘅會員就擔當大律師嘅工作嘅時候，會面對一啲可能一啲嘅民事訴訟啦，或者一啲嘅控告啦。嗱，呢一啲方面咧，我就見唔到話會有基本法或者國際人公約嘅問題。其實法律代表如果係有疏忽或者有不恰當嘅行為，當然第一，公會嘅行為守則裏邊有投訴嘅機制，而法庭亦都喺法例裏邊，普通法原則也好，喺法律執業者條例也好，亦都有相當多嘅規定。如果真係有人受到損失，而有會員係真係違法嘅話，佢哋喺經法庭處理之後，亦都當然有可能係會有民事，甚至乎或者有刑事嘅責任啦。呢啲嘅情況唔止喺香港，喺世界各地其實以往都係有發生過嘅。所以 Alvin， 你第2條問題可唔可以重複一次？
呢個投訴係咪瑣碎？同埋我第3個問題係指佢如果被刑事控告，因為佢擔任呢個某啲案件嘅即係受到資助而被控告，會唔會違反即係佢作為律師嘅呢個責任？
嗱，我諗第一件事就係第一，如果真係有刑事控告嘅話，有相關嘅刑事控告當然係要有法律嘅依據啦。而如果真係有會員係觸犯咗刑事法上高嘅條例嘅話，當然佢哋一定要受到審訊同埋受到法律嘅制裁咧。如果佢哋係有罪嘅話，你現階段問好空泛咁去問，會唔會有基本法或者有國際人公約嘅問題咧？我諗我答你唔到，因為要好睇有關嘅指控係點樣樣。至於我覺唔覺得有關嘅投訴係瑣碎，我並唔覺得有關嘅投訴係瑣碎。原因就係其實當然我哋要明白我哋香港有2個法律專業嘅團體，有2個，有大律師同埋有事務律師。大律師同律師之間有既定嘅合作模式，我哋有我哋嘅收費模式。喺正如我頭先所講，2019年嘅事件，其實有關嘅安排對香港嘅影響，法律界點樣去處理呢啲嘅事件上高，我諗我哋都可以講係史無前例嘅。所以我並唔可以話有關嘅投訴係瑣碎。
有冇其他記者朋友？星島。
星島記者陳志豪。
你好。
想問幾個問題嘅，就話啱啱提到就話個投訴人喺2022年5月作出投訴啦。想問呢個投訴係其由一個單一嘅投訴人作出一次投訴啊，定係有超過一位投訴人嘅作出嘅投訴咧？咁有冇可唔可以透露話呢位投訴人係咪業界人士咧，定係其實係業界外嘅人士啊？而且佢係投訴嘅時候係附帶佢附有自己資料啊、證據啊，去嚟投訴嘅咧，有冇任何？
正如我頭先所講，一如以往，其實有關投訴人同埋被投訴者嘅身份喺法例底下都係保密嘅。今次當然係涉及到公眾關注嘅事件，而且被投訴嘅大律師有38位咁多，所以我哋覺得有需要交代。而你頭先問到其他嘅詳情咧，一如既往，我哋係唔會透露。
好，呢位記者朋友。
Calvin Chan from the SCMP. Just want to know, from the press reports, we understand that it was the police who lodged a complaint. At least one of the complainants is the police. And they do have all the documents in their hand following the criminal investigation, yet they still kind of seem to misunderstand what the connections of these documents. And you said that it's easy for the members of public to not fully understand. Do you mean the police, or maybe that was something that they have missed or they have lost sight of? And are you worried that this conclusion would disappoint some stakeholders in the society and turn into some pressure on the Bar Association as well as the sector? Thank you.
Now, thank you for the question. As I have said, the identity of the complainants and the complainees are confidential. The reason why we are releasing our findings to the public is only because of the nature of the allegations, the number of members involved, and also the unprecedented nature of this whole incident. Therefore, I'm not going to go into the details about the complainants and the complainees. As to the issue of pressure, we are a professional body. We are proud to be a self-regulated body. Therefore, our self-regulatory function is something that the bar take most seriously. The committee that was involved in this investigation was, of course, involved myself, and there were a total of 7 senior counsel involved, all of which have judicial experience. We have also, I can say, because of the number of members involved, we have also used an unprecedented number of, we have used a lot of resources and time to make sure that our findings are safe and also in accordance with the relevant evidence. We can only comply with the relevant rules and also with the law. Pressure or not, I think it doesn't matter with the end of the day because we all got to play by the books.
Any more questions? Okay.
3 questions from AFP. First, without going into the specifics of the complainees and who they are, is there any pattern as to how these 38 people were chosen or any commonalities on why these people are singled out? Or is there anything to be gleaned from this subset of people, especially because such a number is, as you said, unprecedented and large? Second of all, aside from the letters issued to the 4 barristers reminding them and so on, does the HBA think there is any need to review its practices, its way of doing things more broadly for the whole profession? And thirdly, you said just now that the resources for this is huge and it took 18 months. What if tomorrow somebody comes forth? You said this case may not be frivolous, but what if somebody comes forth with a frivolous complaint on this process? Is it feasible to respond to these complaints in the manner
Thank
that
you.
you've done?
I have a terrible habit of forgetting questions when too many are asked at the same time. Let me deal with the last one. We do get very serious complaints, like other jurisdictions. We also get frivolous complaints, and that is also common in other jurisdictions as well. But we have a mechanism that has worked well for years, and we have sufficient manpower to deal with all complaints, serious or not. And we'll ensure that we have the sufficient expertise and resources to deal with all challenges in the future. As to your first question, I think going into that will require me to review matters that are confidential, so I'm not going to go into that. Can you repeat your second question?
Aside from the 4 letters to the 4 barristers,
Yes.
is there a more broader need for review of the way things
I want to say a bit more about the letters. They are in the form of chairman advice, which is a solemn procedure under our rules for me to warn them that although I do not see any, of course, dishonesty involved or criminal conduct or breach that would justify the case being referred to the Barrister Disciplinary Tribunal, they have committed technical breaches of our rules. And that ought to be taken very seriously. And I will make sure that I also speak to the 4 members personally, each of them, to ensure that they are not going to make this sort of mistakes again. Now, going ahead, of course, we, from time to time, will review our rules. In fact, we are also constantly trying to improve our code of conduct. As in relation to the incidents in question, there are some interactions, of course, with the way that barristers were instructed. Solicitors' firm were involved, and we will, of course, have close dialogue with the Law Society as well in order to ensure that we can perfect the system. There are always room for improvement in each and every system, and that applies to other jurisdictions around the world too. But on the basis of what I can see, I think our rules are intact and are sufficient.
Next question.
商嘅電台，頭先提到話今次投訴都大規模咧，即係自己點樣睇今次嘅投訴，即係客觀嘅觀感會唔會係俾人覺得係針對一啲反修例嘅代表律師咧？即係以後律師處理呢一啲案件嘅時候，你覺得會唔會增加咗佢哋壓力咧？第二就係即係點樣睇，即係可能有啲人會不滿今次嘅調查結果，預計佢哋上訴嘅機會大唔大，會點樣處理咧？
多謝你。我諗，正如法庭嘅決定，有任何嘅結果，可能有一些人士會接受，可能有另外一啲會有不解嘅地方，亦都唔係每一個人都會滿意啦。當然，我哋會盡量努力向公眾解説。至於壓力，我只可以同大律師公會嘅會員講，我哋大律師公會有關嘅紀律調查同埋審裁機制，我係一套行之有效嘅機制。我哋亦都只會按有關嘅證據同埋法律原則去辦事。我哋嘅會員唔需要擔心，如果佢哋喺守法同守規嘅情況之下，繼續去執行佢哋嘅業務，我見唔到點解佢哋需要擔心。
由於時間關係，我哋剔交兩條，因為已經過咗5點 ，Chairman 趕住開會。呢一條嚇，請你講名同埋。
你好 K 寶嘅，想問關於23條立法嗰方面啦，其實公會而家有冇收到一啲即係法律界對於23條嘅一啲憂慮咧？咁23條其實個特點係在於即係會透過本地立法啦，覺得個條文上係咪應該即係保留多啲本地嗰個普通法嘅特點，即係包括例如陪審團啊、保釋啊、刑期限制嗰方面應該點樣去處理啦？第二咧，其實就係關於話23條部分罪行，例如即係分裂國家係同國安法有一啲重疊嘅部分，即係公會覺得呢一啲地方應該點樣處理咧？之前有啲意見都話，即係可唔可以取代國安法咁樣？即係公會同意呢啲睇法，點解？係，多謝你嘅問題。23條當然係本地立法，我哋係一個普通法嘅司法管轄區，當然整個法庭嘅審訊程序都會用普通法嘅原則去處理。至於而家講佢同國安法嘅關係啊，或者之後點樣去處理唔同類型嘅案件，我相信我哋見到條例草案嘅時候，會有一啲實質啲嘅意見。而家去講，我相信係比較空泛。
有冇收到法律界憂慮啊？
我諗23條，我可以回答呢條問題。我諗23條係一個公眾同埋法律界都非常關注嘅問題。其實喺過去好多年都有討論嘅，咁而家尤其是當然政府會表明咗會係今年嘅立法啦。我哋亦都當然開始咗做我哋嘅功課，其實都開始咗一排去研究有關嘅罪行嘅。咁至於憂慮與否，我哋收到好多唔同嘅意見，我哋一定會盡力將嗰啲意見向特區政府反映。
Last question. Any idea? If not, I'm going to give to Ling Pao again. Thank you.
多謝。我想問咧，即係就住基本法23條咧，政府經常話咧有急切性，你覺得觀乎而家嘅社會經濟環境，立法係咪有急切性咧？同埋基於2003年嗰個立法過程，大家記得發生咩事？你會覺得公會有咩建議同埋即係甚至教訓，政府可以即係從中吸取咧？
第一件事就係其實基本法23條嘅立法，我諗公會過往都講，我哋同意呢個，我哋係有憲制責任咁去做，所以其實我哋遲早都要履行呢一個責任。我哋都見唔到喺技術上高，當然再褪遲，我亦都覺得未必係最合適。至於教訓與否，03年真係好耐之前嘅事，我諗好多事情都同03年個情況唔係好同啊！我只係重複翻公會嘅立場，我哋第一，我哋係會盡力咁就有關嘅條例草案向特區政府提供我哋嘅專業意見。第二，我哋亦都希望同埋相信咧，特區政府會聆聽各界嘅意見。
時間所限，問答環節到此為止，感謝各位嘅出席。So the media briefing now comes to an end. Thank you for attending. Thank you.